I'm the Director of Public Affairs. I started Minnesota Soybean in 2013. I'm a city kid. I grew up just about 20 miles away from here, Inver Grove Heights, Minnesota. Went to school there, went to the University of St. Thomas then, so pretty much have lived in the St. Paul area almost my whole life. I'm an environmental attorney. As I said, went to St. Thomas, went to Hamlin, got my law degree at Hamlin. My wife's a doctor, graduated the same time I did from medical school as I graduated from law school. So we went out east. We were in Connecticut for 4 years when she did her residency, and out there I got what they call an LLM. It stands for something really fancy in Latin that I don't remember, but it basically means I'm a specialist in environmental law. Minnesota Soybean is two separate entities that function as one entity. You have the Research Promotion Council. Research Promotion Council is what's funding me to be here today. It's the education component of what we do. It's the checkoff. So that's all of our research, international market development, industry, new uses, and producer education things that we do. Minnesota Soybean Growers Association, which a lot of you are members of and are familiar with, that is our membership-based organization that does advocacy. Our federal checkoff is a little bit different than the state checkoffs, such as corn, where we can't use checkoff funds for advocacy at all, not $1. The corn has a little bit more leeway in what they do. They can buy memberships, for example, with their checkoff. Minnesota Soybean can't because we are a federal checkoff. Before I started Minnesota Soybean, I was a prosecutor in a couple small counties, Martin County and Nicollet County in southern Minnesota, south central Minnesota. Spent 5 years doing that. Did everything from ditch cases, ditch law stuff for Nicollet County to child protection services down in Martin County. And I prosecuted in Nicollet County, prosecuted all the violent felons. And I've said so far working with guys like Kevin Papp, it's been a lot nicer than working with the sex offenders and drug dealers and people I used to deal with. My farm experience, this kind of sums up what my farm experience is. I spent 3 years as an intern at the Department of Agriculture, but other than that, it's damn near zero. I don't have a lot. I had a great uncle who had a hog farm down in Missouri. I drove a green tractor through a fence when I was about 7 years old, and that's all I really remember of the farm. So now you know who I am. I'm an environmental lawyer, one of those dirty hippies that's on the other side of most of your issues. But I do really enjoy working for the farmers. I think that there is a lot of regulation, a lot of good regulation that's already out there for you guys, and a lot of economic incentive to do the environmentally right thing. And we'll talk a little bit more about that here in a little bit. So talking regulation and talking impacts, it's important to kind of give an update of where we're at. When I was asked to give this talk last fall, the elections hadn't happened yet. Since then, we now have a Republican majority in both the Minnesota House and the Minnesota Senate. That tends to be a good thing for agriculture. It's not always the best thing for agriculture. We still have Governor Dayton. He has 2 years left, and he has vowed that he will not go quietly into the night, kind of indicating that he still has this year of water action. He's got another water summit coming up, and he still has things to do. So this is setting up right now. It looks to be a pretty big showdown. It is a budget year. The last time we had this type of situation in a budget year, we had a government shutdown. So this year, we don't know if we'll end up with a shutdown, compromise, or if one side will win out over the other. I'm going to get into some of the topics that we're discussing right now at the Capitol, in St. Paul, I guess. Some of the farm groups have been working on this. The first one, regulatory action that I never expected in my life I would ever be concerned about or talking about, is mowing of ditch right-of-ways. The Minnesota Department of Transportation announced last November that they had come up with a new standardized permit for mowing and baling ditch hay. This only applies to land that they control, so it's the state highway roads, the state roads right now. But there's a lot of question there because the law that they're working on, it's an older law. It's from 1985, and it discusses road authorities. And when they describe road authorities, they basically say anybody that's in charge of a road. So there's some confusion right now if this permit, it's a MnDOT permit, but they don't know whether or not they're going to make counties use this permit as well or townships. They've said they haven't, but there's still a lot of confusion out there. from the counties and from some, having some counties adopt this approach pretty readily and some other counties pretty reticent to do this. Like I said, the law is from 1985. Here's the law. I'm sorry, that's kind of hard to read, but basically the law states its purpose right away. It's to enhance the roadside habitat for nesting birds and other small wildlife. It states that road authorities may not mow or till the right-of-way of a highway located outside of a home rule, charter, or statutory city, except as allowed in this city or in this section and sections 160.23, which we'll get to in a minute. They state that for safety they can mow the first 8 feet, but that's it until after July 31st. So from July 31st to August 31st, you can mow the right-of-way, hay the right-of-way, bale the right-of-way, do whatever you want, but they're not going to let you mow or bale that right-of-way until July 31st. That includes if you're mowing your front yard. If you have highway right-of-way as part of your front yard, they have stated that this includes that. The right-of-way may be mowed as necessary to maintain site safety distance issues as well. Still, it can be burned, tilled to prepare for the permanent vegetation planting. They encourage plantings that will help native populations. This issue isn't new. This was kind of surprising to a lot of the farm groups, but this is a U of M extension piece about ditch hay. This piece primarily focused on some of the chemicals that can be in ditch hay and what those can do to your field if you then use the manure in your fields. So some of these chemicals pass through and can cause some serious crop damage. So they were mainly concerned about that, but they did, and this about 2000, the year 2000 this came out, they did indicate, as the law stated in 1985, farmers need a permit to hay highway areas that Minnesota Department of Transportation owns. And they state, this isn't my advice, permits are not needed on roadways where an easement is owned by Minnesota Department of Transportation. That shows that there is some consternation here, there is some confusion in what parts of this highway that MnDOT actually has. That comes from the way that MnDOT acquired the land to begin with. In some instances, they just went out and they got fee title, they own that land. It's pretty clear in that case that they can do this, that they can make you stay out of the right-of-way because it's their right-of-way. Just the way you guys can make anybody else stay out of your land, they can make you stay out of their land. In other instances, they got an easement. And how those easements were written by the Attorney General's office at the time is really kind of where this whole deal hinges. If you there are some specific easements I've seen out there where people retained the right to hay and mow that area. There are some other ones that are just ambiguous on this point. So what you actually have as a landowner really needs to be looked at as far as what those easements are. The new mowing permit that they have is troubling for a number of reasons. The adjacent landowners have priority this month. You need to get in and get that permit this month. If you don't, anybody can come in and get that permit to mow that hay that your family may have been mowing forever that's adjacent to your land. The new permit has a series of requirements that they put on it. The first of which is you need to add the state of Minnesota to a rider on your insurance. That can cost anywhere from $300 to $400. Some insurance policies less, some policies more, but usually it's going to cost about $300 to $400 to add the state of Minnesota to your insurance. You need to have amber flashing lights on your tractor. If you have a tractor that doesn't have them, I have no idea how much that costs because I'm a lawyer, not an implement dealer. But to add that equipment, they've stated that you need to have those flashing amber lights to be able to go out there and do it. Safety vest and hard hat need to be worn while you're mowing or doing the haying. And you need to put in a damage deposit in case you damage the right-of-way. And typically that can be anywhere from $500 to thousands of dollars, depending on how long of right-of-way you're actually mowing. A lot of these requirements seem just crazy to a lot of us farm groups. First of all, the damage deposit for the ditch. You guys aren't really. This is a requirement. All these requirements are there based on people that are putting utilities in right-of-ways, really. So a cable company, somebody that's digging in the right-of-way, where they're doing kind of construction in the right-of-way, where, yeah, you could have some damage. I've never seen anybody hay and mow when there's water out there. It's not when you do it. And the likelihood that someone damaging a ditch doing this is pretty remote. We've been told that this is really just a safety issue, how even though there haven't been any safety problems that we've seen with this outside of farmers having their own tractors roll over or damaging their own equipment, but that's been what they've been saying as the basis for why they're doing this. The real reason, as you know, is stated right in the law. It's for nesting habitat. So there's already bills been introduced to eliminate the requirements, which is, it's good and it's bad. Some of the counties are really worried about that, and I can definitely see their point. There is definitely a need to know who's out there mucking around in the right-of-way. If you leave bales out there, the county, the ditch authorities, whoever needs to know whose bales those are. If they need to get them moved, they can tell you to move them. If there's some other issue, they know who to do it, who to contact. As I mentioned, you need to look at what ownership interest the state has on the adjacent ditches. It's not going to be really clear whether or not you need a permit. I don't think you're going to have to, just from what they're saying, they're trying to say this applies carte blanche, but I don't think that's the case, depending on what your easement says, especially if you retained a right to mow or hay in those easements. Right now, the farm groups have been working. We met with the counties association the other day to work on a fix that should hopefully address all these issues. Basically, what we were looking at is a similar type of permit as a burning permit. Basically, where you just go in and notify them what's going on without having to go through the insurance and all of that. So I think we'll see some laws on that pretty quickly. The Minnesota Association of Minnesota Counties is drafting language to that effect. That 160.23 that we mentioned earlier, that the other reason that this is really important to a lot of the farm groups is you can also mow the right-of-way in its entirety to control noxious weeds. The road authorities actually have an affirmative duty under the law to mow if there are noxious weeds in the field. We've had a lot of issues with people not mowing the right-of-way, with MnDOT not mowing the right-of-way, or a county not getting out there and mow because there are noxious weeds. And it's important for you guys to know that this is in statute. They do have the affirmative duty to get out there and take care of noxious weeds that are in the right-of-way. I know this is an issue firsthand. When I was working in Nicollet County, we had wild parsnip in an area that was controlled by MnDOT, that they owned fee title. They would not get out there and mow it, wouldn't get out there and mow it. So we actually drafted a criminal complaint for the commissioner of MnDOT, and we mailed that to him, and surprise, surprise, the next day it got mowed. Buffers. I'm not going to beat to death too much what the buffer bill is. You guys, or buffer law now, I guess. I've been talking about it so long it was a bill when we started talking about this. Governor Dayton announced he wanted a 50-foot buffer after a pheasant summit, and it came up as an idea to increase habitat. It quickly changed to a water quality measure that affected farmers, primarily in agricultural areas where there was flowing water most of the time. They had this weird formula. They had this bill that came out that basically had this language in it that it had to be a flowing body of water that had water in it most of the year, or most of the growing season. That bill didn't make it out of committee, specifically in the Senate. The Senate never heard that bill. Senator Sparks basically killed that for us in the Senate. It stayed alive in the House, made it through the House, and it was resurrected in the wee hours of the session, 2015 session. That bill was extremely flawed, had a lot of just inconsistencies. It measured ditches differently than the ditch law measured buffers on the ditches. There was some cleanup language that was done in 2016. This is just the language. Pretty much says just this. Buffer law requires 50-foot average with a minimum 30-foot buffer or current shoreland standards, whichever is more restrictive, on DNR public waters. Those are the buffers that are going to have to be in place this November. The other buffer that's needed is on public drainage systems established under 103E. Those are next November. There was an issue a couple years ago with private ditches being added. The original language just said any ditch in a benefited area. That was changed to this language here that has to be a ditch established under 103E. There should not be private ditches that are being added. I know there still are. They're being added under a part of the DNR public waters that we'll get to in a little bit here. There's still some serious problems with the buffer law. Our group has a lot of problems with the buffer law, number one of which being this is a soybean field, but it's more Palmer amaranth than soybeans. So Palmer amaranth is a noxious weed. It is on our Minnesota noxious weed list, even though we didn't have it prior to last year. It was introduced into the state last year through conservation seed mixes. This is an article from the Associated Press. It stated some seed mixes used to grow habitat for bees and wildlife have been contaminated with an aggressive and prolific weed that can be a scourge for farmers, including those in Minnesota. Palmer amaranth was found in the southwest part of the state, and there's a huge concern here that if we have to add as many acres of conservation land that they're talking about this November, there's not enough seed that we know is grown in Minnesota and other states that did not have documented cases of Palmer amaranth to actually be sure we're not adding a huge environmental problem out there to the landscape. Palmer amaranth can take over soybean fields. It can also take over conservation reserve planting areas. It can basically ruin the habitat that they're out there trying to make. The only way to really get rid of it is to burn the area and till the heck out of it, which also is not good for water quality, as most of you guys know. As quote from the Department of Agriculture down there, it's probably the most significant agronomic weed we've seen in over the last 30 years introduced into the state. Another problem is the maps. The DNR maps are done. They're out there on the website. They have gone through a couple iterations here. They have fixed some of the issues. Most of the issues that have been fixed are pretty easy ones. Nicollet County, for example, had a public drainage system that was, we had the map, sent it up to the state. The state took that map. As they were redetermining some of their ditches, they went out and they found a ditch that didn't exist, and nobody that lived on the ditch or where the ditch was could remember there ever being a ditch there. They know it was constructed. They had bills for its construction. They had pictures from the 1800s of it, but since that time, nobody had seen a ditch there. Somebody had filled it in. So it was a pretty easy fix for the DNR to say, yep, it's not there, and to take it off. They also had an instance where a farmer had abandoned a ditch and put in a tile line underneath a field. Obviously, that's not an open public ditch anymore, doesn't need a buffer. They were able to fix that pretty easy too. They have not gotten to the issues of private ditches with a DNR public waters classification. And this is where, I'm sorry, it gets really dorky and boring and legally, but it's a huge problem because the challenge process to challenge those public waters inventory happened when they created the public water inventory back in the 1970s. So if you didn't own the land and your great-grandpa owned the land, whoever owned the land back then, didn't challenge the public water inventory status, you don't really have any mechanism to challenge it now. And that's troubling for me as a lawyer because of basic due process issues, where back when they introduced these public water inventories, the only thing that really applied was a shoreline zone ordinance. That's a zoning statute. With a zoning statute, that's your classic where you get grandfathered in. People are always looking to get grandfathered into a new law. Usually it doesn't work. Zoning is the one area where it works, and they have even more crazy language where they don't just say grandfathered in, they call you a pre-existing non-conforming use. So if you are a pre-existing non-conforming use, you can continue that use as long as you want to, which means that didn't apply to you, which means the public water inventory, who cares? Why are you going to take the time to fight it? Because you can keep doing whatever you want to. Well, now we have a triggering event where you can't, and I think that requires a new challenge process. The state government doesn't quite agree with me quite yet, so we're still trying to work them to convince them of that. Third biggest problem I have, and these are all really 1A, 1B, 1C. To me, they're all right up there. The alternatives. This bill was given to us farmers, and we were told, there's a lot made in the media that we were whining because we said this is a one-size-fits-all approach. They told us, no, it's not. We have language in there. The language says that we can approve practices that will be an alternative to this buffer. So if you're doing something out there like reduced tillage or you have a berm that goes into the ditch, you're not going to need a buffer. There's going to be all these alternatives. Well, here we are, 2 years later after the bill was passed. We're just a few months out from farmers needing to put these ditches in, start planning, buying seed, figuring out what they're going to do in November. We don't have any alternatives outside of being enrolled in the Department of Agriculture's Ag Water Certification Program. That's the only approved alternative as of today. We're told that they're going to get this done here this spring at the Bowser Board, but we have no idea what that looks like. The counties that are supposed to implement this have no idea what that looks like. And it really is going to force farmers' hands to do buffers because you're not going to have time really to figure out something else to do and get that done by November. Number 4, the local implementation. That's another, the alternatives is another huge problem. The soybean growers did fund research to look at a tool called PTM app that Minnesota Pollution Control Agency had developed with Houston Engineering. We had Houston Engineering go in there and look at adding a really easy, quick button so that the different soil water conservation districts could go ahead and see what other practices might equal what a buffer would do. We've had some counties, Mower County is going ahead and doing some of this, but again, it's not approved by the Bowser Board, so we don't know about. Mower County has been nice enough to try to help with this, but in the end of the day, we don't know if that's going to be something they approve. There was money for counties to help implement the buffer bill if they want to in the tax bill that was vetoed last year by the governor. So counties are sitting here too having to make a decision by March that whether or not they're going to implement the buffer bill or they're going to let Bowser do it. And they don't know if the money is going to be there or not to do this. Another problem with the buffer bill that's still out there is the federal government. In 2016, the legislature passed language stating nothing in this section limits the eligibility of a landowner or authorized agent or operator of a landowner to participate in federal or state conservation programs, including enrolling or re-enrolling in federal conservation programs, which sounds fantastic. The only problem is the state can't tell the federal government what to do. It's like if I sat in my office and came up with a really nice thing that said, none of the farmers on our board or my boss can fire me, and every year they have to give me a 100% raise. That's great. It's nothing I'm in control over. So at the end of the day, we still have a problem with the federal government here that needs to get worked out, because what we're being told by the federal government is that conservation reserve programs won't be available after November 1st to farmers. So if you have conservation reserve program on a ditch, that acreage that's coming out in December, you're done. You can't re-enroll it to cover that ditch. There are groups working to change that, but as it stands right now, that's the federal government's point. That's kind of the tack that they're taking with it. The other problem is there's not acreage left in the Conservation Reserve Program to get most of these ditches in place. We're at the cap in Minnesota, so there's not acreage available. So again, farmers were told they could use conservation programs, and they can't. A big question that comes up is whether or not this is a taking. And I get a lot of people that come up to me and say, look, they took my land, and it's what they call a regulatory taking. So a regulatory taking exists when a government regulation limits the use of private property to such an extent that basically the land has no value. In the other instance where we were talking about with roads, it's easy. They say, we're taking your land, we're going to build a road on it. It's done. Here, what they're doing is they're saying, you can't do X, Y, or Z with your property. Well, the government can do that. They can tell you what you can and can't do with your property. The key here is whether or not it deprives the property owners of economically reasonable use or value for their property. I live in the city of Mankato. I own a little over 3 acres right in the city. I could make a lot of money if I opened a casino. However, my land has zoning regulations on it. The courts have said zoning regulations are just fine. They're there for a purpose. They serve the police power of the state to benefit the health, safety, and morals of the community. So now here we have the idea of a regulatory taking. The government has said you can't farm on this land that you've been farming on forever. Is it a taking? I don't know. I have no idea. And it's going to depend on a lot of different things. And I can really, I put this up here just because I can argue each side of this. I can get up here and I could tell you, yes, look, they economically deprived you of this land. Who's going to go out there and mow or hay a ditch in some of these areas where they're at such a severe angle? No one's going to go out there and do that. There's no value to that land. That's also probably not the land you were farming to begin with either. So, the economic value argument, you could make that. I could also go out there and say, look, just like I did with the zoning. It's a zoning ordinance. They can tell you what you can and can't do with your land. There's zoning ordinances that help. In Blue Earth County, we have zoning ordinances about how many houses can be built in a certain acreage. That really protects farmland from some, development. Developers don't want to come in and buy up a bunch of agriculturally zoned land because you can build one house per quarter section on it. They can't put up some monstrosity development. They can't build some casino out there. They can't do a lot of things that keeps farmland values, at least in Blue Earth County where I'm a planning commissioner, I know they have these ordinances, reasonable. Helps guys like Kevin out. So this is just a bunch of language that goes through pretty much what I just said. You can argue it both ways. There are numerous instances where the Supreme Court has found that health, safety, morals, or general welfare are promoted by regulation. There's a new case, 2000, well, not new, in Supreme Court talk, 1980. The application of land use regulation to a particular piece of property is a taking only if the ordinance does not substantially advance legitimate state interests. There's a 2005 case that kind of overruled substantially advanced criteria in the last case. It didn't really. It basically put the burden on the property owner to sue the government in what they call an inverse condemnation, where you say, hey, look, you did something. Rather than the government having to come out and proactively pay you, you have to sue the government. Which that's why I don't know if this is a regulatory taking or not, because it's really going to depend on the facts, and not the real facts, just the facts as found by a judge in your case. So, the land features. If you have a big berm going up to your ditch, maybe there isn't a water quality benefit. Maybe there's not a public health issue there. It's going to be a taking if they make you put in a buffer. The economic value. Maybe you were able to farm some of that land and the economic value really is lost. Then that might make a difference. And expectation. The courts love to look at your expectations. So if you've had this land in your family and been farming it forever, that's your expectation. If you bought the farmland since 2015, they're going to say you knew this law existed. It's not a taking because you bought the land subject to those controls. And there's a case where two homeowners living right next door to each other, in South Carolina. South Carolina passed a law that you couldn't build within X amount of feet of the shore of the shoreland, and so they both had permits to build a house. One had owned the land since his family's owned the land forever. They said, "Yep, it's a taking for him." The other people had bought the house after these ordinances came out. They said, "Nope, it's not for you because even though you had the permit, you knew that this was going on." So it's really going to depend. In any regard, there's been a lot of consternation that the farm groups haven't been jumping up and down and suing everybody yet. The reason we have not is because there's a standing issue. Right now, no buffer has been ordered. No land has been fined. Nobody's been fined for not having a buffer. No buffer's been ordered. We've got a lot of people putting in buffers in anticipation, but nobody's forced them. So there's been no state action. There's been no, what I like to say, punch in the face. If I tell someone I'm going to hit you a week from Thursday, they really can't do anything about it until I actually hit them because maybe I won't do it. So that's really what we're doing here with the buffer laws as farm groups. We're really trying to get this stuff cleaned up, primarily for the reasons I just explained. I think the aggressive timelines were admirable on the environmental group side. I think there was a lot of us in the farm communities from different farm groups that thought that this could work. We were hopeful that it could work, that we could get some answers, but we haven't got the answers. We haven't gotten clear definition on some of these mapping issues. We've encountered new problems with the map, like I said, with the issue of a substantial process to challenge the maps. We've also got no alternatives yet, so I think there's pretty good reasons to delay it and get some of this stuff figured out so we can make sure that this is done the right way. Another issue going on, land taxes. Last year, the legislature passed a tax bill, overwhelmingly bipartisan support, passed a tax bill that would have given 40% relief to farmers who had a new bond school levy basically on their property, and everybody, not just those going forward, but even those past levies that had been done. Passed overwhelmingly, had a lot of support, and that bill was vetoed by the governor over what he said was a one-word error in a provision for the stadium, the soccer stadium in St. Paul. So he vetoed it. They never got back to it in a special session. We've been told that this will be a priority for both the House and Senate, Republicans and Democrats alike, to get this language back in there. The governor has presented a language that has this in there for the budget for this next year. Really what we're doing is kind of keeping on that, and in both the House and Senate, the Republicans have put the number back up to 50% in their proposals. That was where it was originally suggested. It came down to 40 last year through some negotiations. So this year we're looking to get that back up to the 50, so that if you have a new school bond levy, we can take some of that pressure off of taxes. We have farmers in our organization that are actually paying more in taxes than they expect to make per acre because of new school bonds. So that's a big issue for us. Another one is health care. It's been a very hot topic in Minnesota. A lot of farmers seem to be in that 5% of people that saw huge premium increases. Both the premium relief has been a huge issue for both the House and Senate. The Senate did pass some language to do some premium relief. The House has a little different idea, so they've suggested that this is going to go to a conference committee. And while we appreciate their support on that, Minnesota Soybean is still looking at issues with rural access and planned coverages. We don't think it's enough that people just have coverage if that coverage is not really coverage. If your deductible is so high that it still prevents you from really using health care and is almost as bad if you don't have health care, it's just health care in name only. That doesn't make any sense. Another problem is rural access. If you have to drive by 3 hospitals to get to the hospital that takes your insurance, that's not helping anybody either. So those are still issues that we'll be working on. Neonicotinoids, that kind of has calmed down for the most part. That last summer, that was a huge issue. The governor, put out an executive order banning the use of neonics on state land, and he directed the Department of Agriculture to convene a pollinator protection team. That team has met once, and I understand that there was some confusion over to what the purpose of that team was. So the Department of Agriculture has stated that the order requires the Interagency Pollinator Protection Team to develop statewide pollinator goals and metrics and report on the progress toward those goals, as well as providing recommendations for pollinator policy, research needs, and budgets. This is an issue that the soybean growers, corn growers, and other groups have worked on for quite a while. We've done a lot of research into these chemicals. We've actually done a lot of different talks on the stewardship of these chemicals. The corn growers, soybean growers, and some industry partners, along with Farm Bureau, Farmers Union, reached out to Marla Spivak at the University of Minnesota to see if we could create a program that would help pollinators in the state. And basically her answer was, I don't know, because she didn't really know what they needed. So what ended up happening was all of the groups that were involved ended up sending letters of recommendation for her to get a grant, which I understand that they did get, to research exactly what needs to happen. So this is another issue where we think they've put the cart before the horse. They kind of got out there and banned this before they really knew what would help. And we're going to continue to work on this issue. There isn't any pending legislation, thankfully, on this. But it's one of those issues that we think was they really got out ahead of themselves, specifically because of our own discussion on this. Soybean aphids is one of those topics, or one of the insects that they say, look, the farmers are spraying every day for these things, and the seed treatment's a huge problem. Well, we've been saying ourselves for quite a while now that, yeah, the seed treatment is a problem, not in that it kills any bees, but it's wasting farmers' dollars. If you don't live near a lot of buckthorn, you don't see early emergence of aphids in your area, then this graphic basically here from the University of Purdue shows that you put the seed treatment on, the neonics start to decrease. By the time the aphids show up in the middle of summer, it's not there in the plant anymore in northern climates. where we have later infestations of aphids. If you live near buckthorn, you might see aphids earlier than other people. That's the overwintering host for aphids. So we've been looking at ways that we can try to help Minnesota reduce the buckthorn population, basically in an effort to reduce that aphid population so that we never get to threshold and that we can stop using these chemicals. And we wish that was the approach that the government took as well. Quickly, I'll just go over some of the things happening at the federal level. There's pretty much one huge one. Federal government obviously can impact the state, like we talked with the buffer law. How they're interpreting what we're doing is changing how that law will be implemented. And there's now one huge wild card in play. So whether you like him or whether you don't like him, Trump is going to be a big issue for agriculture, I think, in the next 4 years. Starting with WOTUS. So WOTUS is a Waters of the United States rule. This came from another slide, so I talked about another presentation where I go into depth. You want to really have a lot of fun. I can talk for a whole hour about the history of the Waters of the United States rule and only barely touch the surface. So basically where this came from was there's a decision, it's the Solid Waste Agency in Northern Cook County case. In that case, the Supreme Court told the EPA, hey, you need to figure out this WOTUS issue. You need to get a new rule. They didn't do anything. So 14 years after they are asked to do this, they promulgated a new 75-page rule, which became final in August of 2015. When they were creating this rule, they used the Grampanos case and said, we're going to use Justice Kennedy's decision and his test as what we do to define waters of the United States. The interesting there to note is that Justice Kennedy's opinion represented one person on the Supreme Court. There were 4 people that signed on to Justice Scalia's opinion, 1 that signed on to Justice Kennedy, and 4 that signed on to a dissent. Well, Justice Kennedy mostly agreed with the 4. He just had a different test. So this is what they call a plurality decision of the Supreme Court, and they used a minority of the plurality to come up with their test, which is just dumb. But the test that they took, they changed. And they changed an and from an or. Justice Kennedy's test said that the impact must be felt on the physical, biological, and chemical integrity of a water downstream if it was going to be considered a water of the United States. This lowered it because they changed that and to an or. So now it only had to affect one thing. So the way I've been describing this is, we're coming up here on the Super Bowl, and I'm going to have an amazing party, and I'm going to invite you guys all there. But I tell you, you have to wear an NFL jersey that has orange, white, and black on it. There's only one jersey you can show up in. That's the Cincinnati Bengals. That's the only one that has the orange, white, and black. Now, we change that and to an or. Now, what jersey can you wear? Any of them except the Seahawks, who are that one there, and they're navy, gray, and snot green. But every other jersey has white or black on it. So you can wear any jersey. And I should put a caveat on that. They all have the white, black, or orange, but I'm not letting you in if you wear a Packers jersey. So that issue is still floating out there. It's in federal courts. And a federal court decided, yeah, we can hear this challenge to the WOTUS rule. And the government challenged that interpretation. And just in February, they said they could do it. And just recently, the Supreme Court announced that they would hear that appellate court's decision to even hear the case. So this isn't going to get at the merits of the case, but it's going to get at whether or not these challenges are proper. So the Supreme Court will be looking to see, what the challenges are saying is that the WOTUS rule does not promulgate a standard of performance. The standard of performance is laid out in the Clean Water Act, and it doesn't issue or deny a permit. It only defines where the permits are needed. So that's their challenge, saying, look, the appellate courts don't even have a reason to hear this challenge. That's what's going to be decided. But we go back to that wild card. The individual that Mr. Trump has nominated to be his head of EPA, actually reached out to Minnesota Soybean in 2015 or 2014, I believe. And he is the former Attorney General from Oklahoma. He reached out to us because he read in Miniline exactly this argument. And he ended up using this argument before Congress to argue that WOTUS shouldn't be allowed to happen. So I think that we should see WOTUS go away rather quickly if he is in fact appointed to head the EPA. The other big wild card for Trump is an issue that I like to tease my wife about. She's a pediatrician. She believes in the science of vaccines. She thinks vaccines are a good thing. And with Mr. Trump, he doesn't. He tweeted out, healthy young child goes to doctor, gets pumped with massive shots of many vaccines, doesn't feel good, and changes. Autism. Many such cases. He has reached out to Robert Kennedy Jr., who is a vaccine skeptic, and asked him to look into vaccines. And this is troubling for me, working with agriculture, for his other tweet that's up here, responding to someone who is my green hippo. Ben Carson is now leading in the polls in Iowa. Too much hashtag Monsanto in the hashtag corn creates issues in the brain. So, these are some of the things that the anti-vaccine people put up with. And you got the nice hand there holding this vaccine, autism rates. It's got some lesions on his hand, and all these crying kids and all these needles. And when I see these things, they look awfully familiar. They look exactly like the anti-GMO folks' pictures, where we've got fish pigs and tomato kids getting shot with needles and a bunch of pepper with a bunch of needles in it. And this movement to go ahead and challenge something that's very well established in science is very troubling, because I don't know, nobody really knows where he stands on GMOs. This has been his basic only statement on GMOs is this tweet about too much Monsanto in the corn. I don't know what that means. I don't know if he knows what that means. So I see a lot. There could be a lot of problems if the same interests that are getting the vaccines people pushed on him are getting the GMO issues put on him too. This is a slide that I really enjoy. I like a lot because it shows exactly how some of this stuff gets twisted. Fact: water can be chemically synthesized by burning rocket fuel. It's the leading cause of drowning. 100% of all serial killers, rapists, and drug dealers have admitted to drinking water. 100% of people exposed to water will die. It's all true, but it's all just sensationalized, and it's crazy. And I think that this will be a huge issue for agriculture. I think that's a part of what we've seen in the state of Minnesota here is a real overreaction to some issues that, like I said earlier, farmers have a real economic incentive to do the right thing. We've got the PCA has their nutrient reduction strategy, and in there they really criticize farmers. And I haven't met a farmer yet that hopes that their nitrogen, hopes that their fertilizer, hopes that their soil ends up in the Gulf of Mexico. It's just ridiculous to think that that's what a farmer would want. They need their fields, they need their dirt in their fields, they need the nutrients in their plants. They don't need it running down the river. So coming up with better systems, coming up with better precision ag tools that are coming out every day, and working together on some of these issues, I think, is really where the biggest bang for the government's buck really could be. There's a lot of different programs out there to look at these water quality issues that I know farmers care about. I've talked to them. In that vein, the Minnesota Soybean Growers Association, and there's a few on the back table there, have worked with Houston Engineering to come up with our RAPS handbook. And RAPS is a process that the state uses to look at impaired waters. It stands for the Watershed Restoration and Protection Strategy. This is your new TMDL, with your total maximum daily load, or like I like to say, too many damn lawyers process, where this is how they're going to decide what types of practices get funded out on the landscape. Right now, I've been through 2 of these RAPS processes in different watersheds in the state of Minnesota. At 1, I was the voice of agriculture. Now remember, I have damn near zero experience in agriculture. I'm a city kid. I live in a city. I've never lived on a farm. I don't own farmland. And I was the voice of agriculture in the room. What the RAPS process does is it goes through this stakeholder negotiation process. So it takes the environmental groups, the city folks, the landowners who just own it because they like to own land to hunt. It takes the farmers, it takes the businesses, everybody, puts them down in a room and say, where should we spend our money to help protect water quality? What I've seen is the environmental groups go in there and they have ideas. They think that, we need to get buffers, or nobody is doing any kind of reduced tillage, or nobody's doing X, Y, or Z. The truth is, they don't know any farmers. They have no idea whether or not that is happening. It's the same reason they can get people worked up about what's happening in those hog barns, because they only see them as they drive by on the highway. They don't know what's going on inside. They don't know how you guys care for your animals. So if they're the only voice in the room, then the RAPS plan comes up with and says, we need 100-foot buffers on everything. Well, then the PCA is going to go out and they're going to give money to local people to go out there and get 100-foot buffers on everything. And you're going to say, look, I don't need a 100-foot buffer because I got this berm that goes into the river. We're good. And the money's not going to get allocated because the money's earmarked for the things that are in the RAPS plan. So by going to these processes, going through these RAPS things, I've heard farmers tell me, well, I don't want to go because I don't know anything about water quality. You don't need to know a thing about water quality. You only need to know about farming. You go and you tell your story and you tell what you'd be interested in. What do you think would work in your area? Maybe it's targeted wetland. Maybe it's wascobs, whatever it is. You can help define a plan and work together to actually create a better end result for the RAPS program and for the environment in general.